And may it please the Court, my name is Mark Batten and I represent the MBTA in this matter. 30 years ago, the U.S. Supreme Court held that conferring any significant benefit on an employee, and in particular a day off, on the basis of his religious belief, a benefit that is denied in general to other employees, works of discrimination, plain and simple. And the Supreme Court declined to hold that Title VII required such unequal treatment among employees. We are here today because the Massachusetts Commission Against Discrimination has ordered the MBTA to engage in exactly the discrimination that the Supreme Court found repugnant in 1977.
But we've really got an imperfect record here, it seems to me, to decide that question. I may be wrong. And at least in my tentative thinking, it's got to go back to the MCAD. The crux of the case is undue hardship.
Yes, Your Honor, that's true.
The Commission found, well, they could have used other bus drivers. They could have had a voluntary swap, or they could have left the shifts uncovered. Now, we know that those three won't work because the MBTA required part-time bus drivers to work on weekends because they were so short of employees to do it. Mr. Marquez rejected the voluntary swap. He didn't want it. And the full commission said you can't leave the shifts uncovered because we can't have buses and things just, not there. So we're down to payment of overtime, and there's really nothing in the record to show how much of a hardship that might be to the MBTA. Well, not even to mention the union perhaps having to get involved in it. So why doesn't this whole thing just go back until we clarify that point? That eliminates this whole Establishment Clause issue from being considered right now, plus what we do with the Lynn case, which was somewhat divided up here.
What I would say, first of all, with respect to the constitutional issue, Your Honor, is that you don't need to reach that if you interpret the statute not to require this sort of accommodation as an undue hardship. With respect to the state of the record on overtime, the hearing commissioner did find that overtime would have to be paid to cover Mr. Marquez's shift every Friday afternoon. Right,
but was there any sort of meaningful hearing about such things as allowing the MBTA to show how much it would cost, how it would be funded, how many other employees might want to do it or not do it based on religious reasons, whether the union would agree with it, because employees might be required to work overtime against their will if they didn't want to do it. Keeping in mind these weekends are coveted time off, as I understand it.
That's correct.
Wouldn't it have been your burden, though, to put in that evidence?
If that were the dispositive factor, perhaps so. And part of my answer to Justice Brainey's question and also to yours, Your Honor, is that the undue hardship that arises from the payment of overtime is not strictly a financial matter. It's not limited to the dollars and cents cost of paying overtime to other employees. Part of the undue hardship, as we've argued in our brief, is that the very concept of denying other employees their shift preferences, even at overtime, is itself an undue hardship, regardless of whether it costs the MBTA $1 or $1,000.
Well, I have a question, a basic question. The union seems to argue that there was no, the union says that there was no conflict with the collective bargaining agreement at that time because Marquez was on probation and because there was no seniority preference system in effect at the time. Now, it seemed to me that you were arguing that there was a seniority preference system in effect.
Let me clarify.
So I couldn't correlate that.
There are actually four parts to the response to that question, Your Honor. First of all, I would note, sort of proceeding from least important to most important response, that fact is not in the record that was before the MCAD. It's not in the record that's before this Court.
What fact? That there was no seniority?
That there was no seniority provision in 1997. It's also not clearly true because if you look at the supplemental appendix that the union submitted, at the very end, it attaches a collective bargaining agreement. The preamble dates that agreement at 1977, and it includes in Section 220 a provision for selection of days off by seniority. But even accepting that the union's brief is correct and that there was no seniority provision at the time in 1997, it is undisputed that that provision was in the collective bargaining agreement by the time the hearing commissioner made his very first initial decision in this case. So that
but what does it matter if it's in effect at the time he makes his decision? Isn't it whether it was in effect at the time that this all was occurring, the incident?
not solely, Your Honor, because the MCAD has to fashion a remedy that is consistent with the statute and
Okay, so it
consistent
would
with the
affect the
Constitution.
remedy, not the...
Yes, that's absolutely right, Your Honor. It might only affect the remedy as opposed to the question of liability. And then of course, the question of seniority standing alone then also doesn't address the
Can I
the
interrupt
question
you
of
again? Following up on Judge Botsford's question, the issue of hardship was tried in front of the hearings officer?
Yes, it was, Your Honor.
What evidence did you put in of hardship?
The evidence was that because there was a shortage of employees at the time, and there was no cover list, as has been discussed in the record, of employees who were sort of free to be moved around from one shift to another, that the only way that Mr. Marquez's absence on Friday afternoons could have been accommodated was through the payment of overtime, which incidentally would have been payment of overtime to an employee who had acquired sufficient seniority not otherwise to work on Friday afternoons. And there was also testimony about the efficacy of a voluntary swap and the hardship that would cause to the
So on the overtime, the only thing you put in was what you just mentioned.
Yes. There was no evidence in the...
There's no cost analysis.
That's correct. That's correct. And we submit that the existence or non-existence of the cost, while perhaps relevant, and as Justice Botsford says, perhaps our burden to put in, and we didn't, is not dispositive of the question.
I'm not quite sure what evidence you could have put in, because if in fact who works overtime on a given Friday afternoon in order to accommodate your client depends on the level of seniority, and I take it that wages lies with the level of seniority, and I don't know how many hours, when you click into time and a half, which I assume is what the overtime is, probably it could be something different. It would be very difficult to calculate what the actual, I suppose you could calculate what the highest cost would be if you took the highest employee.
Well, and you'd have to, that would probably satisfy the question about Mr. Marquez individually, but not the larger question of if we're going to have this new rule, how many other employees are going to need it, and when we get new hires, how many of those are going to require it, that sort of thing.
Can you help me out on the Lynn case? You know our Lynn case? Lynn.
I'm sorry, Your Honor.
Well, Lynn deals with a provision in 151B, 17, Section 17, sub 4, that says it's okay to discriminate.
The seniority system.
If you have a bona fide seniority system. The Lynn case held that that was applicable, as I recall it, only to age discrimination.
That's correct.
So if the Lynn case is still good law on that point, this is not an age discrimination case. So therefore, that statute comes in to effect.
Well, that is the reason, it's because of that case whose name I had just misplaced.
Lynn, yeah.
Thank you. That we had not argued in our brief that the exemption for bona fide seniority systems controls this case, because if it weren't for Lynn, this case would be over in that sense, because the statute specifically says that a bona fide seniority system is sufficient to, and would constitute undue hardship. Lynn takes that out of the equation and prevents us, if the court is going to continue to say that that section only applies to age cases, then the MBTA can't take the benefit of that.
So then you
exemption.
have to say Lynn is trumped by titles, the way the U.S. Supreme Court has interpreted Title VII.
I don't think it requires you to say Lynn is trumped. Lynn stands...
Trumped and not overruled, because they can't do that. But
I would submit, Your Honor, that Lynn would be irrelevant one way or the other, because all that Lynn says is, MBTA, you cannot rely on Section 17. That exception deals with age. That's an entirely different subject.
But in terms of what you can rely on, you seem in your brief to rely a great deal on the federal case, which I can't remember. Yeah, Hartson. But isn't it the case that our section for religious belief, at least the court has held in the, I can't pronounce it, PEIL,
That's the way I say it.
is different in origin and meaning than Title VII?
There is a glancing reference to that in PLEC, yes, Your Honor, although I submit that the couple of sentence discussion of that in PLEC is dicta, because it was not, the question of undue hardship was not presented directly to the court in that case. And turning from that to now actually focus on the question of undue hardship, the only difference between the text of 151B, and as usual I think we have no legislative history, but just looking at the text of the statute versus the text of Title VII, The only difference is that Chapter 151B, and this is what PLEC references, listed some examples of things that would constitute undue hardship. We know that's not an exhaustive list, in part because of the way the statute is phrased, and also because the Commission itself in its own regulations says these are just examples. Undue hardship may be other things as well. And so we submit that the addition in Chapter 151B of some examples of things that would be dispositive as to undue hardship doesn't answer the question about comparing it to Title VII. There ought to be some more principled policy reason to say Chapter 151B is different from Title VII, and we're not persuaded by the explanation in Hardison.
Have we ever said that 151B is different from Title VII?
Only
Yeah,
in...
well,
only
But
in,
it
yeah.
is particularly on this issue of de minimis, isn't it?
Yes, it was, Your
I
Honor.
mean, which is what you're relying on, isn't it?
In the context of saying that the purpose of the point of the PLEC decision was to say that on its face, Chapter 151B doesn't violate the Establishment Clause because it contains this exception for undue hardship. And in the course of that, the Court did say that de minimis is the Title VII rule. Chapter 151B looks different to us because it has these examples.
But you say it wasn't in this context, and so it's an open issue, you would say.
The question of undue hardship, yes, Your Honor, is a significant enough one that we should submit to you that PLEC, although it does say what Your Honor says, ought not to be controlling, and that this is an important issue like this ought to get a fresh look in a case where the issue is actually presented.
Well, the issue is actually the issue is actually presented, but it's going to be presented, excuse me, on a very, very regular basis. PLEC, as I recall, was Christmas Day, correct? Was that?
Yes.
It was,
No.
it was an amendment to the statute, and whether
No,
the
I
amendment
understand that,
applied.
but this is every Friday,
Correct.
and I think one can almost take judicial notice of the fact that there are several religions whose Sabbath begins
Sundown Friday.
Sundown Friday. So
Yes.
it's not as if you're talking about, potentially one is talking about a fairly significant group of people here, correct? I mean,
Absolutely.
I assume.
Absolutely, Your Honor.
I mean, I don't know too many religions which begin their Sabbath at the Sundown Wednesday.
Correct.
The
Correct.
Sundown Friday.
And then that accentuates the conflict in this case because, regrettably, it means that the Sabbath for Seventh-day Adventists and other religions happens to be a day that everybody wants to have off, and that at the MBTA you have to have 3 years of full-time seniority in order to earn off.
Can I ask you this? In looking at this, why shouldn't we follow the reasoning in New York City Transit Authority, the reasoning of the Court of Appeals in New York?
Because the reasoning of Hardison is more persuasive, Your Honor.
Well, I mean, this is certainly decided long after Hartson.
Yes, it is. Yes,
And
it is.
it really talks about, this statute requires good faith on behalf of the employer, and that means not that something was actually found, but that a genuine search for reasonable alternatives was undertaken, and then has a list of things that weren't even tried.
Because that goes to the sort of the second part of this argument, Your Honor, which is about whether an employer can be held liable under Chapter 151B for not following a certain procedure.
Well, it also goes to whether you've met your burden of showing that you couldn't make a reasonable accommodation. If you haven't acted in good faith to explore alternatives and you can't demonstrate that, then how have you met your burden?
Because we have two alternative ways, and the Commission's own cases that they cite in their briefs say this. We have two alternative ways of prevailing. We can either undertake the search that Your Honor describes and show, look, we've looked at the following 6 things, we talked to a bunch of people, and it's clear that that's not going to work. Or we can present evidence through a knowledgeable individual who says, I don't need to talk to anybody else. We can tick off the possibilities. We know what they are. Overtime, voluntary swaps, et cetera. They're not going to work, and here's why. And the hearing commissioner here found that witness to be credible, at least so far as to say overtime is going to be required in order to cover this spot.
I don't see where the commissioner made that finding. I'm having a hard time. Could you point to that?
Yes,
to
it's
me?
paragraph 25. It's page 9 of the appendix, paragraph 25 of the hearing commissioner's decision.
Epps testified that in order for the complainant to take unpaid absences each Friday, the MBTA would have to pay overtime to cover his shift.
Correct.
And that this was not feasible. Okay. That's what he testified to.
Right. And well, in all of the... if
Epps
you-
testified that MBTA bus drivers were permitted to arrange voluntary swaps with other drivers using word of mouth or postings on bulletin boards. Although part-time drivers were not supposed to voluntarily switch shifts with full-time drivers, the MBTA policy against this practice was loose, and it happened frequently. He also makes that finding.
Yes, he does.
And so the MBTA explored that option?
The MBTA did not explicitly explore that option in this case, but the question is whether it matters that it didn't, and whether it can be held liable for not engaging in that. If, in fact, it would impose undue hardship on the MBTA to rely on the whim of some other swapping employee every week, as we submit it does,
Which was against your policy anyway.
which was against our policy anyway, however it was,
But not your practice.
in some cases, not our practice. But
I mean, it just strikes me that what the hearing officer is saying here, in essence, is that you guys really didn't do anything. You really didn't do anything to try to accommodate this. You just said, hey, we got a seniority system and not going to work.
And even if I don't dispute that, Your Honor, that is what the hearing commissioner found, and that the MBTA didn't do an investigation, I submit that does not excuse an analysis of whether, in fact, there is undue hardship anyway.
What
Because
about
otherwise,
the evidence from, I think your human services person or something like that, who said, she testified that there was somebody else who had been accommodated for about 9 years.
that evidence is in the record as well, yes, Your Honor.
So,
But that doesn't mean that the fact that the MBTA accepted undue hardship in one case doesn't mean it has to do it repeatedly.
but it doesn't mean it has to, but that would go to rebut your statement that you can't do it. It seems somebody testified on your behalf that it's been done and it worked.
Well, it was done through the payment of overtime or other things that the MBTA
Yeah, but
chose not to do.
isn't
in
it
this
true
case.
that you have the burden?
Absolutely.
So then, isn't it your burden to show that you can't do it?
It's our burden to show that it would be an undue hardship for us to do it. Not
And-
that it's
and you-
impossible.
Okay, right.
And I think that, as I understand, part of your complaint, and it's explicated more carefully in your reply brief, is that we can look at the way our system operates and say, these are the constraints within which we operate. The only thing that we can do to accommodate, the only thing we can do to accommodate this is A, B, C, D, and E. B, C, D, and E are not feasible. That leaves us with A.
Correct. The North Star for this analysis throughout has to be, is there undue hardship or is there not? And if the MBTA fails to prove that there's an undue hardship, I acknowledge that burden is on us. But there cannot be, I submit, separate liability imposed on the MBTA because it didn't do some investigation that someone thinks ought to have been done. The question is, what does the record show about undue hardship? And we submit that on the only options that anyone on any side of this case has ever suggested, it was absolutely clear that undue hardship would follow.
Thank you, Mr. Batten.
Thank you.
Mr. Katz, as I understand it, you have 7 minutes.
Yes, Your Honor. I'm the attorney for Mr. Marquez. The MBTA's appeal should be rejected for 3 reasons. First of all, pursuant to 151B, the MBTA has the duty of proving why the actual decision-maker made the rejection, why the actual decision-maker rejected Mr. Marquez. Now, Mr. Marquez was rejected by John Langan, who's the chief personnel officer, by himself without consultation of any other person. Mr. Langan rejected Mr. Marquez out of hand without taking any steps of any kind to make any attempt to accommodate Mr. Marquez. Now, pursuant to 151B, the MBTA had a duty of justifying why Mr. Langan, the decision-maker, rejected Mr. Marquez out of hand without taking any steps. Now, in this case, remember, their burden of proof is to prove why John Langan rejected. In this case, the MBTA never called Mr. Langan as a witness, number one. Number two, MBTA never put in any evidence of any kind as to why Langan rejected Mr. Marquez. MBTA never explained the behavior of Mr. Langan, why he rejected Mr. Marquez out of hand.
But some evidence got into the record of possible reasons why he was rejected, some of which was just quoted. And as I understand it, they made it into the hearing officer's opinion, and then were analyzed by the full commission. I'm talking about swapping, trouble filling shifts on weekends because couldn't get people to do it, et cetera, overtime, and so forth.
But, Your Honor, there's 2 different questions here. They have to prove why John Langan rejected Mr. Marquez. The evidence, as I will get to, is that John Langan independent evidence that John Langan rejected Mr. Marquez because of bad faith and had nothing to do with undue hardship.
Okay.
I will
That's
get
a
to
different-
that.
that's a
now,
different
it is
story.
unacceptable under 151B to reject someone without giving any evidence to justify why they were rejected out of hand. Which brings me to the second point. MBTA's whole case, 100%, rests on the testimony of Mr. Epps. Now, it is impossible for the MBTA to prove their case through Mr. Epps. Number one, Mr. Epps testified that he had no idea why the MBTA rejected Mr. Marquez in 1997. He testified that he testified that, as far as he knew, Mr. Marquez had been rejected by the MBTA in 1997 because of bad faith. Number three, in any event,
Well, wasn't the MBTA's position that he was rejected? He was rejected because not to have done so would have been undue hardship on the MBTA.
there was
Isn't
no
that-
proof of any.
Go ahead.
Mr. Epps, first, Mr. Langan didn't testify. Number two, look at the record. Mr. Epps testified that accommodation was possible. Appendix 647. There's an error. It says 618. It's 647. Mr. Epps is asked, this is a problem that the MBTA might be able to solve, might have been able to solve in 1997? Epps answers, yes, yes. Now, look at the brief. Look at the brief. What happens in this brief? They take the testimony of Mr. Epps. The brief writer says it proves impossible. Mr. Epps never said at any point in any of his testimony that it was impossible to accommodate Mr. Marquez. What Mr. Epps says, if you read the transcript, Mr. Epps says you cannot guarantee accommodation. That's all he ever says. He never says it's impossible. Now,
But impossibility is really not the question here. It's undue burden.
he never says that they can't do it. That's the critical question.
But where did the hearing officer come up with all this stuff about swaps
Okay.
and
Your-
paying overtime and discontinuing
Your
the
Honor.
shifts, discontinuing the routes on the
The
weekends?
only specific quotation in the hearing officer's findings is referring to pages Volume 1, page 197, Volume 1, page 212. That's his reference. Let's look at the page. Let's look at what those pages say. Volume 1, page 212. The question is, if Mr. Marquez ever became a full-time worker, full-time employee, could you assure his accommodation? Remember, a person can be a part-time worker as long as he wants. He never has to become a full-time worker. In the record, it says, if he became a full-time worker, and then he says, the question was, could you assure accommodation? So that has nothing to do with saying that Mr. Marquez, as a part-time worker, could not have been accommodated. There's no dispute that we can't guarantee accommodation. 150-51B never guarantees accommodation. Second point, with regard to page 197, which is the only other place where the MBTA makes a reference to his testimony, it's referring to the question of cost. And could you have accommodated by leave without pay? And it said it would cost. And then he says, but it would cost, but it's unlikely they could have done it. That's all he says, unlikely. But Mr. Epps never looked at anything. Now, let's go to the
Mr.
question.
Katz, could I just ask you, the MCAD didn't, you're arguing it has to be reversed, it has to be, the MBTA can't win here because they never did anything to show about the actual decision maker.
Right.
That's not the basis of the MCAD's decision, is it?
Yes, it is. Read it. If you read the MCAD decision, the Commission decision, you read the Superior Court decision, they're saying that they never made any effort. They never proved any effort, which means they never proved why John Langan rejected. Under 151B, say I come to you for a job and I'm rejected because of religious accommodation, and you're the one who rejected me. If I go to the MCAD, they have to defend why you rejected me in this. Mr. Epps never had anything to do with the case into the year 2000.
I understand your point, Mr. Katz, but it seems an unusual one in this respect in many institutions. In many institutions, the decision maker may be aware of all of the policies at issue, That it doesn't have to be that decision maker that testifies about the policies at issue. And then I know you said Mr. Epps didn't read any documents. He didn't have to read any documents necessarily.
One critical point going to the weight of Mr. Epps, besides the fact, is the fact that when he looked at the data, he admitted, quote, that he never looked at the data with any purpose of trying to achieve accommodation. Appendix 641, he was asked, in preparing your testimony today, did you at any point go through all the documents for the purpose of finding any possible way that Marquez could have been accommodated? Mr. Epps answers no. He never looks. 151B at its heart requires good faith effort. He's coming in as a defense witness. Now, the point that you just raised, Mr. Epps admitted that before he testified that the only document he ever looked at was one record from one of the 5 stations, which means he never looked at any actual data about cost. Remember, he's referring about a decision he never participated in that happened years in the past. He admitted he never looked at any data. Everything that he's talking about is from the seat of his pants as a defense witness. Now, he also stated that he was violating his own principles in testifying that day. He said, he was asked, if your goal was to try to achieve accommodation for Mr. Marquez, what would you have done? And he gives a list of what he would have done. I would have gone to the labor relations. I would have looked at the data. I would have done calculations. But he didn't do that because he was there as a defense witness. He says that if he was trying to accommodate it, he would have done quite differently. And he says, honestly, he could have been accommodated.
Thank you, Mr. Katz. Ms. Ward?
Madam Chief Justice, may it please the Court, Beverly Ward for the Commission.
Was there any attempt to strike the testimony of Mr. Epps or to say that there was no basis on which he could testify?
Not to my knowledge. There were questions as to whether he had personal knowledge.
No, I understand that, but if there was no basis, if the claim is that such as what he was testifying to was irrelevant because it didn't satisfy, some view of what the appropriate evidence was, presumably what one does is move to strike all that evidence. So the evidence is in.
Well, it wasn't
The evidence is in. There was no.
The Commission relied on it.
Yes.
Well, it's
yes, Your
actually
Honor.
more, it was evidence, but it was more lack of evidence from what came out of his mouth. But where did the hearings officer get all this information, evidence, whatever you want to call it, that caused the hearing officer to talk about voluntary swaps, paying overtime, discontinuing routes that they couldn't staff on weekends, and all that kind of stuff? Where did that come from?
Let me.
Did he say, here's things you can do based on nothing in the record?
That information comes, I think, from the testimony, perhaps, of the 3 defense witnesses, the 2 human resources persons, about the process that they'd practiced in the past, and from Mr. Epps. The issue in this case is, it's not what they woulda, shoulda, coulda done, but what they didn't do. There's nothing in the testimony that indicates that as to that specific hiring or non-hiring, that any analysis, a specific
Let me give you a specific example. Let's say I'm an employer, and I happen to know, I have a retail store. I know that. And I know that it is an enormous hardship. I've got whatever the minimum number of employees, to bring me subject to 151B is. And I've got 3 people who've worked for a very long time, and they are parents, and they want to leave on a Friday evening. And I am hiring a new person who comes in and says, I want this job, but my religious beliefs, principles, tenets of my faith mean that I have to leave by sundown on Friday. As I understand both your position and Mr. Katz's, that employer has somehow got to do an investigation, go and ask these people, would you be willing to accommodate?
I think that the nature of the investigation would be determined by the nature of the employer and the specific request.
I understand, but we have to make rules here, and I think the thrust of the MBTA's position, and maybe it's not valid on this record, is that given what existed, there was no way to accommodate except, overtime.
Your Honor, that is not what the decision says, and those are not the facts that came out in the testimony, or this is a 30A, what the hearing commissioner found. There were a number of areas that could have been explored.
Such as?
Such as they have employees that they hire solely for the purpose of what they call covering, and the hearing decision mentions covering. Those are individuals whose sole, my understanding of it, sole purpose is to
At least the brief of the MBTA says that in 1997, there was no cover list.
Your Honor, that was not, let me go back. That was not placed into evidence to the best of my knowledge.
What's the MCAD relying on then, if
the
it's not
MBTA.
in evidence?
Your Honor, the MCAD is relying on the testimony of Mr. Epps as to the practice. The other issue in this
Now, wait a
particular
minute,
case, as to what was the testimony that was elicited,
Mr. Epps said in 1997 there was coverage?
they discussed, the testimony was in general, how the policy and practices, that they did have a cover list.
They did or didn't?
Mr. Epps could not testify, if I remember correctly, and this is that whether or not a cover list did exist. Now, and when I say
But then
that,
how can the MBTA say one of the things they could have done was explore the cover list? So that's problematic. What's the other thing they could have done?
there's a cover list.
Well, we've just realized that there's a problem with the cover
All right,
list.
well, let me go back, if I may, because much of Mr. Epps' discussion and testimony related to assignment to a specific location, which was generally done on the basis of where the potential driver lived, location. There was no exploration of what existed at other garages and other locations and other shifts. I think that the MBTA would be obliged to look beyond that hypothetical, because we don't actually know necessarily.
Are you saying in essence that the judge, and I know this is a summary judgment proceeding, but that she totally misanalyzed the case?
No,
Because she begins by saying, I'm going to quote now, the MCAD found that the MBTA could have used any of the following methods to accommodate Marquez. 1, don't cover the shift. 2, overtime. 3, swaps. Then she goes on to say they argue that this causes an undue hardship.
Okay,
Now, is she wrong in that? Is that part of the case? Because
No, the commissioner is not wrong. I don't know that that's an exhaustive list, but the point of those findings is, in fact, that there were methods available to accommodate. This is really a series of issues in this case. The first issue, Your Honor, is the interactive process. Mr. Marquez, in this case, I believe, testified that he offered, to do a 4-day week. The MBTA keeps arguing that it's an undue hardship because it would be day in, day out, every Friday, and that's just not the case. It's one shift. Excuse me. It's one shift.
Well, it's week in and week out.
Yeah, but it's the shift
Well,
that
it's
nobody
not
wants
every
to
week.
do. It's the shift that nobody wants to do.
Well, and again, Your Honor, I would submit that
Can we take judicial notice of the fact that there are many people who have Friday at the beginning of Sabbath as sundown on Friday?
Well, I think, yes, Your Honor, you can
And
also
then
take...
what are we going to do? We're going to then say that that's not a... We're going to have courts looking and the MCAD looking as to whether somebody who says that they're a Seventh-day Adventist or some other religion that has Friday, that these are not really practicing Seventh-day Adventists.
Well, I would say two things. The court would then, I think, be required to take judicial notice that there are many employees, probably of the T, whose Sabbath is Sunday.
Yes,
the
and then the MBTA is going to have the same problem on Sunday.
Then the test, Your Honor, becomes, is it a sincerely held belief, 1, and 2, under the circumstances presented, which can be fluid with employers, on a case-by-case basis, is it an undue hardship? Certainly, had the MBTA put sufficient evidence in to establish an undue hardship, that would be a different situation. In this instance, there's not even an evidence that there was an analysis, a mental analysis done, or any type of analysis before they said it's an undue hardship.
Thank you, Ms. Ward.